have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay?
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, cause damage to the apartment complex after a breakup with a significant other. The complaining witness stated that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property, I believe that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. Defendant pushed his way through complaining witness and a witness. A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. Defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment,
That's correct, Your Honor.
his apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, so typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
Okay, what all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leasees, the people that lease the actual
Because
premises.
if it belongs to the other person, then
3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to.
so it's like, it must be, cans that offices put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with
I don't see how that was interference.
because what would they possibly put him in custody for?
So, Your Honor, just to clarify, I'm not, what the DIMS say, and they go to the great lengths to explain this, is that there was a deputy there who was serving some sort of civil paper.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
detain the defendant, because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the papers.
Correct.
It's not really clear from the information. Is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers,
I think I agree with you on the interference,
yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward in the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Asher Burger, the only thing I'm going to ask you now, well, I'm going to order you is not to go back to this place, not to have contact with the complaining witness.
I
Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail.
I
You
understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
Okay. So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. My be excused?
Yes, sir.
Thank you.
Martha, do you have an arrangement?
No, there's still an arraignment. Okay.
Yeah, I don't think that there's much, but
All right, Judge, date 10, Gonzalez, come on up. My left thumb.
all right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness say the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank the beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that said the defendant will slap CW and show up at, slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man, or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
Okay, what was it said exactly again?
Judge, the message that the defendant sent to complaining witness states, exactly, bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm gonna find no probable cause, ma'am. As the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you, you could end up in hot water. I'm gonna find no probable cause in this case. The idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble,
Right.
I mean, you now know. All right, man, please, just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait. Otherwise, you're free to go. Okay.
All right, Judge, next is page 12. Guzman, come on up.
That hearing had a little bit of everything. Judge Fleischer presided over a morning docket where the charges ranged from property damage to verbal threats, and his steady mix of pragmatism, caution, and even a little plain talk shaped the outcomes. Case involved Mr. Asher Burger, accused of causing $405 worth of damage at his former apartment complex after a breakup. The allegations were that he broke 3 flower pots and 3 trash cans, then returned to the leasing office the next day and pushed past staff during a disturbance. Law enforcement tried to detain him, but he initially got away before being caught later. Judge Fleischer carefully parsed the facts, questioning whether the damaged items actually belonged to the complex or to tenants, and expressing doubt about the interference charge tied to the deputy serving civil papers. In the end, he found no probable cause for interference, but allowed the criminal mischief charge to proceed. His tone was measured but candid, telling Burger to stay away from the property, avoid contact with the complaining witness, and reminding him that picking up new cases could land him in jail. Burger, respectful and cooperative, agreed readily. Next came Ms. Gonzalez, charged with making a terroristic threat against her sister. The backstory was messy family drama. She had been told not to enter her sister's residence, but her nephew accidentally let her and her husband in. Later, when confronted by text, Gonzalez responded with angry messages, threatening to slap her sister and show up at her job. Judge Fleischer read the texts aloud. "Bitch, don't talk out your ass, 'cause I will go to your house and slap you in front of your family. I'll even come to your job," and immediately noted the problem. The statute required a threat of serious bodily injury, not just heated words. He found no probable cause, dismissing the case outright, though not without a warning. Quoting the old adage, "sticks and stones," he reminded Gonzalez that words can land someone in hot water and urged her to avoid injecting herself into toxic family dynamics. The overall atmosphere was serious, but occasionally conversational. Judge Fleischer was pragmatic about the limits of the law, dismissing charges that didn't meet the statutory threshold, but still cautioning defendants about their choices. Both Burger and Gonzalez were respectful, if subdued, and left with clear instructions. It was a morning that showed the court's balance of accountability, legal precision, and a reminder that sometimes the best way to stay out of trouble is simply to walk away. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,